This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. The city has settled a lawsuit filed by Janae Edmondson. She's the volleyball player who lost both legs after being hit by an out-of-control motorist in downtown St. Louis. Her lawyers say she got screwed because of the state of Missouri. Do they have a good point? A former sheriff's deputy who was forced to roll golden dice to keep his job, only to still be fired, has sued the sheriff's office. Why did he sue for defamation instead of wrongful termination? And we've got more litigation from Attorney General Andrew Bailey. He's suing Starbucks, claiming its workforce has gotten, quote, more female and less white. Is that an actionable offense? Now, as you can probably tell from all those legal questions, today is our Legal Roundtable, and we've assembled 3 top attorneys to help us better understand these matters of law. And today, that includes Arindam Carr. He's a shareholder at Nelly. He focuses on antitrust compliance, counseling, and government investigations. He also provides outside general counsel services to higher education institutions and emerging entities. He also regularly handles pro bono immigration matters. Arindam, welcome back.
Thank you.
And we're also joined today by Nicole Gorovsky. She's a former prosecutor in both state and federal court. She practices today at Jenkins and Kling PC. Nicole, welcome back.
Thanks for having me.
And last but never least, today we are joined by the one and only Bevis Schock. He is in private practice in Clayton at Schock Law. Bevis, welcome back.
Thank you, Sarah.
So a teenager from Tennessee who was maimed in a terrible car crash in downtown St. Louis has settled her lawsuit against the city. Janae Edmondson will get $450,000. Now, that might not sound like much in light of some of the recent nuclear verdicts against big corporations in the St. Louis area, but it's just a few $1,000s under the cap that the state of Missouri has placed on municipal liability for instances like this. Her attorneys at Simon Law, Nicole, they say that's not fair in light of the massive bills that she faces for her recovery. Do they have a point here?
Well, I agree with them that it's not fair, but it is the law. So we have statutes that when you sue a sovereign like that, for example, the city, there are caps on damages because of sovereign immunity. And in this case, it's amended by statute every year to increase a little bit. But I believe in this year, the cap was $517,316. So it was within that cap, and whether we can argue all day legislatively whether we should have that cap or not. I think not.
But we have it. Does that mean even with a settlement, the city could not go above it, or that just means that's the max a jury could dole out?
Well, if that's a max a jury could dole out, no settlement would ever go higher than that, if that's their highest risk if they go to trial, right?
Yeah. The city knows that's a card they can play in
Correct.
The settlement negotiations. Arindam, in light of that, do you think this is a pretty good settlement here that her lawyers were able to obtain for her?
Listen, as a parent, I can't even fathom what the Edmondson family has gone through and what they're trying to get through. If there was an opportunity, knowing this cap, that you could save the family with some grief of trial and all the things that go along with preparing for a trial, maybe it was the right decision for a family. I don't want to step into their judgment, but it's certainly something that would be a consideration for any family when you have sort of that type of limit and what makes the best sense for the family in terms of getting something but not putting the family through that.
So Janae's lawyer, this is Kevin Carney of the Simon Law Firm, he said the Edmondsons decided to settle in part because of the cost of taking it to trial. Here's a quote. Janae and her family are better off settling for this amount rather than paying for the expenses of a trial and then waiting to be paid while the case would work its way through years of appeals. That's coming from her lawyer there. Bevis, say that they went to trial, they won the maximum under the cap for the state of Missouri, would the city also be on the hook for their costs at trial, or that's something they'd have to eat?
The cost of trial would have been maybe some depositions, filing fees. I don't really buy into what Mr. Carney is saying here. I think what happened was the city said, we're going to push on this a little bit. He went to the clients with the $450. I just settled one against the municipality for $452. And the reason is that's about a 15% haircut. You get your money now, it's over, move on. I'm sure that was the family's objective. To me, the interesting question is, should we have caps? And if so, at what amounts? they're two different questions. The history of the thing was that the king could do no wrong. The king was called the sovereign, and so you can't sue the king because the king could do no wrong. But somehow we plop that into the city of St. Louis can do no wrong, which sounds wrong.
When you put it that way, yes.
But on the other hand, you have to look at it from the perspective of the taxpayer. What if it's a $100 million verdict, then the city can't provide services anymore, there's no money. The way the rules of execution work, execution is when you try to get money after you've won the judgment. The bank accounts can be attacked, but the actual buildings can't. So sovereign immunity does make some sense to me. I don't know whether these are the right numbers. It seems a little low. This is an extraordinarily bad case, life-changing in the worst possible ways. Now, you can certainly argue that this young lady got hit because the guy was a lunatic criminal and there was nothing wrong with the traffic. I think the city settled partially because they said we actually might win. This dude's allegation of bad traffic signs probably was pretty weak. The city said we need this one to go away because of the PR problems of the city's crime factors.
Yeah. So you mentioned what they were actually suing about. As journalists, we try to shorthand this in a way that makes sense. And we say, okay, they sued because she was maimed by this out of control motorist, or, it comes down to downtown has a problem, or we have a crime problem. This really had to do with the city allegedly being negligent by installing a yield sign at a low visibility intersection in which drivers' views are obstructed on both sides by high-rise buildings. Kind of like the least sexy description ever. Nicole, why would they sue over that versus you allowed this criminal to run amok? Your then circuit attorney let things get out of control. All the things that armchair quarterbacks have been saying in the city about this case for the last 2 years.
So I think this is an interesting thing that a lot of public people don't know, which is that sovereign immunity is actually a bar to recovery to a lot of things. And then there are certain exceptions to the sovereign immunity doctrine, one of which is a dangerous condition of property. So you kind of have to shoehorn certain cases into fitting that exception to sovereign immunity in order to bring it. And that's what this one was. So if they wanted to argue under the exception, they had to claim that this yield sign was a dangerous condition of property that contributed to what happened, as opposed to just saying, this guy should have been in prison. I mean, that would have been barred by sovereign immunity. So basically, they had to shoehorn it into a dangerous condition of property. There are very few exceptions to sovereign immunity. That's one of them. Another one of them is dangerous operation of a motor vehicle. So a lot of people don't know that. But yeah, you have to make it fit into one of those exceptions.
Okay, so the yield sign becomes the sort of opening to let them get into court. If they just were trying to argue over you shouldn't have let this young man out of jail, they wouldn't even be able to get this far.
That's right.
Wow. So you may have a question for our Legal Roundtable panelists. We have 3 top attorneys here with us today. You can give us a call at 314-382-8255. Again, that's 314-382-TALK. Another high-profile legal dispute had some surprising developments this past month. Now, as we've discussed, the rapper Nelly was sued by his former bandmates, the St. Lunatics. Now their former producers are suing both Nelly and the bandmates. Brothers David and Darren Stith allege that their D2 Productions, Inc. is owed at least $10 million in unpaid royalties. This backstory is kind of interesting. The brothers say they let Nelly out of his contract the month that his hit record Country Grammar was released. They got just $75,000 for that. They thought they'd still get royalties from Nelly's songs because they had contracts with the members of the St. Lunatics. They say they've now learned that Nelly and the St. Lunatics had a, quote, secret agreement that allowed Nelly to get sole credit for the songs, and that he apparently secretly gave the bandmates money, maybe under the table, and that let them avoid paying these brothers royalties. Arindam, if there was indeed a secret agreement where Nelly got the credit and the St. Lunatics got the money, but no credit, do you think these producers might have a case here?
That's a big jump still.
You're not persuaded?
Not quite. I mean, the secret agreement, if it's a conspiracy, it could potentially toll the statute of limitations here. I mean, we're talking about agreements dating back to 2002. So there's a challenge there. And frankly, we're talking, I tried to count this, at least 4 contracts that they're arguing about. 2 of them may have been oral. We're talking about substantial amounts of money. So there's this thing called statute frauds. Do we need a writing for some of these things? So there's a lot of stuff to get through here. So yeah, I'm not ready to jump to that point, but I'm ready for the behind the music sort of documentary on this, definitely.
Yeah, this is going to make for a great episode. Yeah. You mentioned this all happened 23 years ago. So statute of limitations, this would normally kick this out of court. They can't even bring this up. But you're saying conspiracy could change that?
Sometimes if there is, and you often see this in class actions, if there's a conspiracy that's hiding some sort of secret agreement that's hurting you, there's an argument that statute of limitations doesn't toll. It really starts upon sort of knowledge. And that's in some of the things that you're seeing, that these brothers didn't realize that all this had happened until sort of ironically one of these lawsuits that said there was a secret agreement. So
yeah, it's interesting how the St. Lunatics are the ones who brought this into court, and now the secret agreement may come to light that could cost them some money. Nicole?
Yeah, I suspect this might be some legal wrangling around the statute of limitations. I mean, so we have statutes of limitations in Missouri that bar lawsuits after a certain amount of time. What we also have in Missouri is something called a discovery rule, which is so when you're first capable of ascertaining your damages is when it starts to run. So if they say that they weren't capable of ascertaining their damages because these agreements were secret, they have sort of 2 arguments to try to get around the statute of limitations. One is they weren't capable of ascertaining it. 2 is that there was a fraudulent concealment that prevented them from bringing the lawsuit. So that, I think, is this secret agreement is some legal wrangling to try to get around the statute of limitations.
So you think they're painting these facts maybe with a different sort of brush, knowing it will help persuade a judge to let this case stay in court?
I think it's their only chance.
Bevis.
If these people walked into my office with this case, I would have given it about 3 minutes and said, get on your way. And the main reason is, if they think that they were the creative force behind a successful song, they hear the song, they hear the melody, and they say, I did that. They did know about it. They knew about it because they were the creative force behind it. And they should have said to Mr. Nelly right at that time, hey, wait a minute, you just stole my song. You can't do that. So I think this is a total loser. And I know the attorney who's the plaintiff's lawyer. He's a good lawyer and a smart guy. But, I mean, I wish him well. That's all I can say. And maybe they're going for some settlement value, and maybe it does have some settlement value, just to not fool with it. But there's no way I would take this case.
Wow, Bevis would turn it down cold. Arindam, I know this is probably not a case that you can speak on behalf of a large law firm when it's not your area of expertise. But do you see a little bit here where you'd want to open this door? You'd maybe want to get Nelly a piece of this anti-Nelly action.
The opinions are my own and not of my law firm. So I think that's my standard disclaimer on these things.
Fair.
A lot of tough facts here. I'll put it there.
Okay. So Arindam also not super psyched about this case. Nicole, I know you sometimes like to tilt at windmills. Like when they're bad windmills, you're there. You're ready to fight that fight.
I do like to try to run through brick walls. And as a former plaintiff's attorney, I liked it even more. But I don't see it on this one.
Wow. Okay. Well, I wanted to root for the secret agreement being brought to light, but apparently lawyers who actually understand what the law says, they've got a different take on this one. We're talking today to our Legal Roundtable. That's Nicole Gorovsky. We're also joined by Arindam Carr and Bevis Schock. We're going to take a quick break. When we come back, we're going to talk about a sheriff's deputy who's filed a defamation claim against his former boss, and also Andrew Bailey takes on Starbucks. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Gemma, architects, planners, and designers seeking to bring joy to their clients and communities. Details at gemastl.com.
Welcome back. I'm Sarah Fensky. I'm here because today is our Legal Roundtable. This is where we gather some of the greatest legal minds to be found in St. Louis. We bring them together. We try to get them to argue a little bit or at least enlighten us to the state of the law. I always learn so much from our panelists. And today that includes Bevis Schock. He's at Schock Law in Clayton. We're also joined by Arindam. He's a shareholder at Nelly, who focuses on antitrust compliance, counseling, and government investigations. And we're joined by Nicole Gorovsky. She's a former prosecutor in both state and federal court, and she practices at Jenkins and Kling PC. So a former sheriff's deputy is suing the St. Louis City Sheriff's Office. St. Louis Magazine, I got to take some credit for this. This was my team. Ryan Kroll broke the story last week that former Deputy Tony Kirchner had been forced to roll a pair of golden dice in order to keep his job. If he got a 7, he could apparently stay employed. Well, he did roll a 7. The sheriff told him, yes, okay, you've got a job. Well, he got fired a few days later anyway. Now Kirchner has filed a lawsuit, but he's not suing, at this point anyway, over the dice. He's suing over defamation, over a statement the sheriff issued this past weekend trying to defend the dice roll. Bevis, do you think this guy has any case that he was defamed? I mean, he went to the media. The sheriff ended up sort of issuing a statement trying to rebut what he said to the media. Now he's suing for defamation.
This new sheriff, who everybody thought was going to come in and bring some sanity to that office, has been a disaster, and we're only a couple of months into it. I mean, I know it's the wrong topic, but he arrested the lady who was running the jail because she wouldn't talk to him or give him some video that he could have gotten later in some way.
I do want to clarify, he did not arrest her. He did, however, handcuff her. He did this to the acting jail director.
Well, I think so. I know a lot about what an arrest is, and there's a lot of law about arrest. And when you put the cuffs on and take them somewhere, that's an arrest, and that's exactly what he did. He doesn't even have what's called a post license, police officer standards training. That's when a person has the certification from the state of Missouri to actually arrest someone. It's common for elected sheriffs not to have that. This guy's a disaster. So I think this defamation case is just have at the dude. I mean, he's going to be gone so soon. This guy cannot possibly stay.
So Bevis doesn't even care what the law says about defamation. That's the kind of expert analysis we like from our panelists. But yes, I mean, you're making a good point here. I do believe it was a deputy that put her in the handcuffs, not the sheriff himself, but the sheriff apparently ordered it. And so I think Bevis's point stands. His knowledge of what constitutes an arrest, I will definitely defer to him on this. Nicole, do you think there's a good defamation claim here?
Yeah, I mean, to get into the boring and finer points of the law, I do not think there's a great defamation case here. I mean, so I think that, and I'm not sure I have the comment exactly right, but I think he said something like he felt that the man, Kirchner, was getting emotional about his firing and that he was trying to diffuse the situation. And look, I'm as disappointed in the sheriff, maybe not as much as Bevis, but, I think, this situation is insane. But a defamation case, if it was his opinion, I don't know how you're going to prove that it's not true. If it was his opinion, so you have to prove that something was published, you have to prove that something was false for defamation. And so if it's something, there's tons of case law that if it's something that is your opinion, it's very hard to prove that that's false. So if the sheriff comes forward and says, look, it was my opinion that he was getting emotionally charged, I don't think it's true. Let's put that out there.
Sure.
But if that's what the statement is, I don't think it's officially legally defamatory.
Yeah, I think the statement was that he was exhibiting significant emotional distress, that the sheriff was aware of the potential for an unstable reaction since this deputy was armed. He had to deploy a creative de-escalation strategy. This statement was somewhat jaw-dropping. Some reporters were sharing it over the weekend going, whoa, this is something else. Arindam, do you think there was anything defamatory in it?
No, I mean, I concur with our panelists here that, I think it's a tough case. I think it gets to the point of, a couple things. And one thing I do want to note, it wasn't just golden dice. I believe the sheriff said they were magic golden dice.
He said they're rigged. I think I heard that one
They
today.
were trick dice.
I mean,
yes.
Since we're talking about facts and whatnot,
that's important.
so that was what was in his statement.
Does that help him or hurt him legally?
It was his opinion. They were magic dice. But yeah, I think the larger question is, if he was let go, fired, whatever. Some of the things I was just trying to figure out: lack of a wrongful termination lawsuit, which maybe is coming, maybe not. I was just trying to figure out. I welcome the other panelists. Are the deputies under a collective bargaining agreement? Is there a policy here that we need to look at, or are they at will? These are all sort of larger questions, I think. Despite the events here.
Yeah, I believe they're at will. This is one of the last remaining patronage offices in the city. And Bevis, I don't know if you can...
I think that's right. That's what I've heard. But then he can be fired for any reason or no reason, but he can't be fired for a racial, national origin, religion, veteran status, a few more reason.
So any reason, say that he had not rolled the 7 on the golden dice, but there was no discrimination against him for being over 40 or being a white guy or whatever, that would be legal.
I think that's one of the shocking things that a lot of people don't know when they call an employment lawyer, is that employers can be jerks as long as they're equal opportunity jerks. So if it's not a protected reason and an illegal reason, there's not a lawsuit there.
That's fascinating to me. And Bevis, I saw you nodding. So you kind of you concur with what Nicole just said.
Absolutely. And I think it's also the correct policy. And the reason is otherwise nobody hire anybody. You're going to have a free market in labor. So people come and go from jobs all the time. That's normal. That's the right answer. And if a person is a jerk as a boss, word gets out, they have trouble hiring. That's normal. That's all fine.
And that's the point I was trying to get at, that if there was, if the deputies were part of a union or a collective bargaining agreement, then there would be certain standards and restrictions on whom you could or could not terminate. And that's the sort of, I think, question that I had on this.
But otherwise you could. Yeah,
absolutely.
So, okay, here's a question. The deputy got 2 rolls. The first one, he didn't roll the 7. Then he does roll the 7 with these trick magic dice. Is there any legal argument that could be made that the sheriff reneged on a promise? Bevis?
Anybody who would agree to be bound by the result of the dice is too stupid to be a deputy sheriff.
Well, and what's actionable about that? Like, so let's say he did renege on a promise. That's not the basis for a lawsuit either, unless it was a contract.
Yeah, and you couldn't try to claim it was an oral contract that he says, if you roll the 7, I'll let you stay on.
We're in completely insane land, but I think not.
Offer, acceptance, consideration, all these little...
It's personal services contract, so it's not enforceable anyway.
Oh, see, this is why I love to hear from lawyers here. We are in insane land. And that leads us to a good question that came in from Gary writing on X. Bevis, this is one you might have an interest in. Gary asks, what is the executive/legal process for the sheriff's removal? Do you know, are we looking at a quo warranto like was filed against Kim Gardner?
I think so. There's a list of offices. Probably he, as an elected official, is on the list. So the AG will be coming in on his horse pretty soon and filing that.
What I also found interesting, I did go to the sheriff's website just to sort of see requirements and thresholds, and they tout that it's the same requirements as the President of the United States. You have to be a U.S.-born native citizen, 35 years old, whatever the requirements are.
They make that analogy there.
They're proud that that's the same requirements as the U.S. President. So
interesting.
The more you know there.
Feels like maybe we didn't have quite as robust a primary to get us to that point. Okay, one more question I have here about this matter. Again, I know we're in insane land, but Tony Kirchner's lawyers have said they will be bringing more litigation over what happened to him. And one of the things that they talked about at a press conference last week is that white deputies were being, quote, systematically removed from the department. And this was maybe part of what happened to him. I was very surprised to see that they filed this defamation lawsuit so quickly. And they're saying another lawsuit related to this same deputy might be coming. Nicole, don't lawyers generally try to roll these things up into the same lawsuit?
Yeah, I think if it comes from the same nucleus of operative facts involving the same parties, I think it's going to be in the same lawsuit. I think, the claim that white deputies have been systematically removed maybe implies that there are going to be other people coming forward and new lawsuits involving those other people. But I think we're just going to have to stay tuned.
And we'll probably end up talking about this in the coming months. I have a feeling this sheriff, as long as he stays in office, he's going to provide plenty of fodder for the Legal Roundtable. I should also note, our producers tell me that Attorney General Andrew Bailey has removed sheriffs in Iron and Ray counties using that quo warranto. So it appears that that's the process. Bevis, your prediction is he's going to jump all over this?
I think so. I mean, this guy is at a different level of crazy. And what he did with that jail commissioner is a violation, I think, of her constitutional rights to be free from an unlawful seizure. If he did that, that is a federal crime. I mean, I would love to represent that lady in a civil rights case. That's a slam dunk.
You're just putting that out there.
Just putting that out there.
All right. Well, Missouri Attorney General Andrew Bailey, we're just talking about him. He has made some headlines this past month for a lawsuit against Starbucks. He's accusing them of discrimination on the basis of race. He says the coffee chain uses race and sex-based hiring practices, that it unlawfully offers exclusive training and employment benefits to select groups, that it had goals for minority representation at both executive levels and in its stores. He says those things violate anti-discrimination laws. Bailey has pointed to a Supreme Court ruling outlawing racial preferences at Harvard in making this case. Bevis, this case has drawn some guffaws from the peanut gallery. Do you think Andrew Bailey has a decent case here?
I do. So I think factually, Starbucks claims all this as something to be proud of, that they do this exact question. So it's not a factual challenge case. It's a law case. By law, I mean, what is the law? Now, the Harvard case, they got after Harvard because they receive public money. However, the private entities are also subject to EEOC, Missouri Human Rights Act, and I think there's some juice there. So I agree from a policy perspective that should be stopped. I don't think people should be hired on the basis or receive any benefit of their color. I think we need a completely colorblind society. I think that's where he's headed here. Whether it'll work, Nicole is shaking her head.
I sure am. So I think and I've said this before on this show, I think we are ushering ourselves into a new era where people are filing lawsuits for the cultural effect as opposed to the legal, merits. I don't think there's any legal merit to this. And you're absolutely right, Mr. Schock, about the fact that the Harvard University case was because they get federal funds. And so that's a completely different situation. This is a completely private company. The first question I have is, what standing does Andrew Bailey have to even bring this case? He's not sitting there with an employee representing an employee who's been discriminated against by Starbucks. He has no dog in this fight.
Can I pop in here?
Sure.
Because I was very interested in that question and wanted to pick your brains about it. I think this is his attempt to have standing. This is a quote from the lawsuit. Missouri's consumers are required to pay higher prices and wait longer for goods and services that could be provided for less had Starbucks employed the most qualified workers. Do you think I'm reading that right? That that's his attempt to have standing, that this is affecting Missouri consumers? I see Arindam maybe shaking his head.
Well, and I do think that's his attempt to have standing, and I read it as well, and it has a lot of statements kind of along those lines in the lawsuit, and I felt as I was reading it, it was Shakespearean me thinks thus doth protest too much. It's just they're trying to, fit a square peg into a round hole. There is no standing here.
You don't see standing on that issue. Arindam, do you think there could be maybe more artfully done standing over something like this? Like consumers are suffering because of this corporation's policy.
Yeah, I mean, I think the Attorney General has, and I'm going to butcher the Latin here, parens patri jurisdiction. So he can step in to protect the citizens of Missouri. One of the hooks is the consumers, the Missouri Human Rights Act, things that he believes are being violated by Starbucks policy. And I think to Nicole's point, and I'll kind of split the baby here, I think there are sort of some distinctions on sort of what's happening. There is absolutely a cultural piece here, which is this, and again, my opinion of an offensive attack that that there aren't people working at Starbucks, and this correlation of long lines or messing up an order is tied to the person's, ethnicity or gender. That's one argument. I think that's a novel argument. I think that's going to be tough to prove. to, I think, Bevis's point, I think there's going to be a little bit of a challenge here of trying to apply the Harvard and North Carolina cases to a private company, albeit what's really interesting in the complaint is they do state a fact that Starbucks is a federal contractor. So they have some federal contracts. So query whether there is public money going in as a federal contractor. I don't know about the standing for implementing some of the executive orders that are on DEI right now, but I think that's the other hook that they're trying to kind of shoehorn some of the issues at the federal level and trying to apply it here to, again, what I think is a novel piece on the applying it to a private company. The one last thing I'll add is, now I do think there is absolutely a concern for corporations of trying to apply equity as opposed to equality. And so to the point that there are programs that are elevating certain historically disadvantaged ethnicities, backgrounds, genders, to try to bring them to some level within an organization. I think those are the things that many corporations are looking at, because those are the things that I think are really going to have some legal concerns here if there's a broader application of some of the Supreme Court cases.
Those were very popular in the Biden era.
Yeah.
You think companies now have some reason to be concerned they could end up with this sort of lawsuit?
I think it's worth
could be in
revisiting
trouble.
to see how those programs work. And again, to the extent, I don't know if these were quotas, which I think historically have been issues, but to the extent that there are numbers involved, I think that's something that they also need to look at.
I mean, if they say in a document, we are going to give special training to people of a certain racial background, I mean, that's, in my opinion, terrible. And it also, I think that it's correct that leads to bad service. I mean, if people get promoted for reasons other than merit, probably the coffee isn't as hot or the correct strength in my latte would maybe not as good. Maybe what's going on is that Bailey's hoping there's going to be an employee pop up and say, I'm jumping in here, and then his standing problem is resolved, I think.
And I do want to challenge the fundamental premise that we had a meritocracy before any of this happened. So I think there's a question on the premise there, too.
I think all of these things are really interesting to debate, and they're all really interesting to talk about. But I am incredibly concerned with this overarching premise that we're not staying in our lane. We're filing lawsuits to make cultural change. We're issuing executive orders to make legal change. We're really messing up our system of government in the United States right now, and I think this is an example of it. You might be absolutely right, Bevis, that there's a problem with their policies, but this is not the appropriate way to go about it. And we're losing the United States if we don't go about things in the appropriate way.
So you don't like the idea of a state attorney general saying, I'm going to take on how Starbucks operates. That's sort of fundamentally a concern.
If it's a completely frivolous lawsuit and doesn't have a basis in the law, yeah, that concerns me a lot.
Bevis, anything you'd want to say in response to that?
I think that, respectfully, I don't think that past discrimination is the reason to have laws and programs today. I think we just say, shoot the gun, everybody start racing, good luck. That's my opinion of from a policy perspective.
Well, yeah, I mean, that's, I guess, sort of a policy prescription here. And I know we are trying to stay a little more focused on the law. Arindam, is there anything legally? Well, I mean, if I wanted to get into the policy debate, I probably would have booked a couple different types of guests here. I didn't invite anyone saying, please defend, the history of affirmative action in the United States. I said, what do you think of the Starbucks lawsuit? So
fair enough.
Keep us on point here. But there are certainly these bigger issues underpinning it. And there's also the issue of how does policy get made in the United States, which I think Nicole raises some good issues about. Arindam, what's on your mind as we're sort of hashing through this issue?
No. I mean, I think I'd just go back to the point. I think there are absolutely cultural issues. And again, I think the legal system has often been used to impact cultural change. I mean, go back to the civil rights movement. And so it can be a vehicle, depending on sort of what your lens is and how you're viewing it. You either view these cases as good or bad. I think legally here, you do have to look at some of the employment practices and reread and re-review the Missouri Human Rights Act, perhaps the Merchandising Practices Act here in Missouri, a couple of the other things. And again, I think the hook of the federal contractor in trying to bring in some of the federal opinions in as it applies to the private company, I think are legal reasons that not only this organization but other organizations are repeatedly and constantly looking at right now in this new age.
Yeah, I'm fascinated by this idea, and I think we got sidetracked with so many other ideas ping-ponging around. Starbucks may have a very small federal contract. Let's just say for the purposes of argument that they're making less than $1 million a year from a federal contract, and at the same time, they're this giant company bringing in hundreds of millions of dollars. Could that be enough to open the door where the feds could say, this is like Harvard, you take our money. We've got you now.
Yeah, I don't think I don't believe, and I'll defer to others, that there's a threshold test. If you're a federal contractor, you're a federal contractor, and you have to comply with the rules and regulations under that contract. They probably have GSA contracts at federal buildings serving Starbucks. So, yeah, I think that's definitely a hook that they need to look at.
They're on a lot of military bases, I know. In fact, I think they have Starbucks on some of the aircraft carriers.
Do they really?
Floating Starbucks.
Okay. Well, I guess Starbucks, if they made that sort of deal, they now have to live with the consequences of it. Bevis, I want to go back to one thing you mentioned. Say that they have employee groups that are only open to people of a certain race, and you're saying that should be off limits. My understanding of how Starbucks did this is it was sort of marketed to one group, but there were ways that it was sort of open to everybody, that they would say, we want people who've traditionally not been represented in the C-suite. That might be socioeconomically, that might be racially, it might be genderishly. Do you think that would help them with that legal problem, or are they still in the same hot water potentially?
It might help them, but what I read was that the company's bonuses to some senior people actually is affected by how they do according to hiring people of certain races. Now, if that's true, they're busted.
I'll add one last thing. Any organization, when they get litigation like this, whether there's merit or not merit, there's a risk profile that companies have to understand. And one of the things that most, if not all, companies don't want to get involved is in litigation in which they have to get involved in discovery, meaning they have to share information, even if there is a protective order that keeps confidential. There's a litmus and an understanding of sort of like where this is. Can it get past sort of that first stage of can this case go on where there's going to be the exchange of information? So I think that's another profile that not only Starbucks but others would look at in these types of cases of like, do we have to sort of quote unquote open up the books and share information, even if there's nothing to hide or be worried about?
I think
something they don't want to do.
I think that's ultimately the real goal and point of these lawsuits. I don't think they are concerning themselves so much with the legal merit as with what public headlines they can make and what information they can get.
And Nicole, we did have a question that came in through Blue Sky. AK writes, quote, I'd like to learn more about what the AG's office historically did before these types of lawsuits that seem to go nowhere. What kind of work are the people of Missouri missing out on because of the times and resources that go to filing a lawsuit against Starbucks? This AK writes, I'm counting on Gorovsky to have a lot to say about this. We just in a couple minutes.
A call out on Blue Sky.
Yes, and that's a great question. I used to work there.
Yeah.
And so, look, I think we have a history of at least the last two AGs filing these type of lawsuits. And so these are very different types of attorneys general that we've had in recent years. I think before that, attorneys general were concerned with real consumer complaints. They were concerned with, remember the no-call list? That was a great thing for Missourians. They were concerned with actual concerns of Missourians. Now I think they're concerned with being a stepping stone to higher politics and filing these newsworthy lawsuits. I think it really has changed.
So we are going to have to take a break here. Just two quick things. First of all, our producers tell me Starbucks has received federal contracts to supply coffee machines and equipment to the Department of Navy. Since 2004, Starbucks has received $2.7 million from the federal government for purchase orders. So comparatively small number, but as Arindam says, that may not even matter. So this is our Legal Roundtable. We're talking to Nicole Gorovsky, Arindam Carr, Bevis Schock. When we come back, we'll talk about the Warren County prosecutor who got removed from office. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky here with our Legal Roundtable, digging into all the issues that involve the justice system here in the state of Missouri and the city of St. Louis. And boy, there's a lot to talk about this month. I'm joined today in doing that by Nicole Gorovsky, a former prosecutor in both state and federal court, now at Jenkins and Kling PC. Also joined by Bevis Schock, an attorney at Schock Law in Clayton, and Arindam Carr, a shareholder at Nelly. So the Warren County prosecutor has been removed from office for reasons that are a lot more prurient than just getting a degree in nursing. Hannah Dunnicky allegedly had nighttime ride-alongs with a married sergeant she was having an affair with. That made her a witness in some of the very cases she was set to prosecute and created, quote, obvious conflicts of interest in at least 200 cases, the county's presiding judge said. So she has now been removed from office. She's fighting back. We'll get to the fighting back in a minute, but how serious is that kind of conflict, Bevis?
It's very serious. In all criminal cases, the defendant has a right to have all the information that might help him or her achieve a not guilty verdict. Certainly, the fact that the prosecutor is having an affair with the chief witness, the investigating sheriff, would be that sort of material. The technical term is called Brady material. The remedy for a Brady violation is the conviction is thrown out. So I think the presiding judge has a very, very strong point here. What she has done is terrible, and control yourself, young lady.
And also, young man, this married father of 5 that was also apparently a part of this. Nicole, you were a prosecutor. I imagine this sort of conflict is one that prosecutors actively sought to avoid.
We hope so. I think we can certainly debate the ethics. I think it's a problem. Absolutely. I don't know if it actually rises to the level of Brady material. It's not exculpatory. It does lack, the disclosure of another witness on the case. I don't know if it's actually exculpatory evidence.
Because they would have had to say she was there. That wasn't
right. And
shared.
I think it certainly should have been disclosed. I think it's a problem, without a doubt. I don't know if it rises to the level of a Brady material violation, but this is certainly an ethical problem, and I think this prosecutor deserves to have some kind of punishment. Now, whether the action is the right one is a different point. So apparently this judge just went and took action to remove the prosecutor. We have other methods of doing that. We have, again, quo warranto seems to be the Sesame Street word of the day. We have those actions for, these purposes. I'm not sure a judge can just issue an order removing a prosecutor. I think that's a very interesting issue here.
Yeah, so her attorney, this prosecutor who was removed, wrote that allowing a judge such power would, quote, provide a system for which interim prosecutors would serve at the pleasure of the judge, which is an alarming proposition, as the court is required to ensure the fair administration of justice. And we should mention she was an interim prosecutor. She had been appointed by the judge. He then sort of withdrew this appointment. But to the bigger point, Arindam, does her lawyer make a good point here that raises some concerns that judges shouldn't necessarily be deciding who gets to be the county prosecutor?
Yeah, that was the one of the questions I had when I read the order in terms of what was the jurisdiction, how did this present itself before the judge to do this. Now, notwithstanding that question, another word of the day was he used the term paramour to describe the deputy, not the band, but the illicit lover, which, when you read a lot of opinions, it's always good to see some interesting language in there. But so, yeah, I do think that's a big question. And notwithstanding, again, this issue of the ethics and being a witness and these ride-alongs, the judge went on to list sort of a litany of issues. And again, I haven't been in this person's shoes, but I can only assume an interim prosecutor in a county that doesn't have a lot of support does get behind a lot of stuff. But the judge kind of listed all these things of like missing all these deadlines and not putting in witness lists and
filing 24 cases past the statute of limitations expiration date.
Exactly. And then went on to do these traffic tickets where didn't put a court date on them, and there were like 100 tickets that went out without a court date. And so then again, if the person who has the ticket doesn't know when they're in violation of the court date and things like that. So there were a lot of things that, again, I think there are appropriate channels to question and potentially remove a prosecutor like that. I think that's one of the things that, to your point, is probably a valid question.
Why wouldn't the presiding judge of St. Louis City have removed, Kim
Gardner?
Of course. I mean, and of course the answer is that didn't happen. The Attorney General came in with this quo warranto, which is a legal term that means when the Attorney General or sometimes certain other people can bring an action to remove someone from office. That's what a quo warranto is. And did this judge call the Attorney General, call the good Mr. Bailey and say, hey, this is disaster. You got to come in here with your horse and get rid of this lady. And you'd think he would have done that. Now, the other angle is he said, I'm going to write this order. These facts are so bad, let her challenge it. Let's go ahead and have at it. And he might have this argument that he appointed her as an interim so he can remove her as an interim. Maybe. I don't know. That sounds kind of goofy to me. She wasn't elected.
So this judge has kind of taken action. She's now challenging that action. Could Andrew Bailey ride in and just quo warranto this and say, we don't even have to worry about what the judge did. I'm here to do my job.
I think it's going to be like this, Sheriff. There's a resignation ahead of us.
We will see. And this might be one that, again, we get to talk about next month. Now, a lawmaker is targeting a judge over some rulings the lawmaker didn't like. House Speaker Pro Tem Chad Perkins filed a bill targeting Cole County Circuit Judge Cotton Walker. Now, legislators can't remove judges, but Perkins has filed a bill that would rearrange 2 of the 4 circuit judgeships in Cole County that would basically lead to this guy's removal. Nicole, let's say he can get the votes. Would this be maybe a legal way to do this thing that lawmakers aren't allowed to do?
Yeah, I mean, I think my other theme of the day is going to be stay in your lane. I mean, so no, the legislator shouldn't be doing this, but they're kind of trying to do it. He's kind of trying to do it in a roundabout way, which is kind of getting rid of that judgeship position and then saying, Cotton Walker, you will have to run against another sitting judge, and then it'll be harder for you to get your position in the future. So it's kind of a tricky way of trying to do it. But I mean, he has made, I think, no secret of the fact that it's because he doesn't like Cotton Walker's rulings. And I think I looked it up, and Jefferson City has no shortage of cases. They're not going down in the sense that they need one fewer judge. So I think it's a veiled attempt to not stay in his lane.
Arindam.
Yeah, one thing I think for our listeners, if they're thinking about recent elections, like, well, I don't remember judges being elected here in the St. Louis region. So one of the distinctions, as I understand it, is unlike Cole County, judges are elected. And so they're not part of the nonpartisan court plan, whereas in St. Louis and Kansas City they are, where you just have a retention vote. I think this, again, kind of gets to that policy issue as well as a balance of powers issue of, the legislature getting into the judiciary when they don't like certain things. There are some plans that sort of insulate and protect judges so they can be independent and provide what they're supposed to do in terms of adjudication of cases and potential rules and laws that are up. This one might be a scenario where, shows sort of the ills and the concerns of when the judiciary becomes highly political because there is an election involved.
Give me 10 seconds. If you ask this Republican legislator if he's in favor of the federal Democrat effort to pack the Supreme Court of the United States, he would go berserk and say it was the worst thing ever. And he's trying to unpack the Cole County Court. That is a disgrace.
So you don't see this as democracy at work. You're troubled by this,
Oh,
Bevis.
I am deeply troubled. There are certain things people, even when they can do them, they shouldn't do them. FDR should not have run for his 3rd term because we had a better country when it was done by an understanding of how we come together as a community. This guy has got to leave the judiciary of Cole County alone, or he's going to be said, hey, are you in favor of packing the Supreme Court of the United States? Well, then quit unpacking the Cole County Circuit Bench.
I agree with Bevis.
Wow.
Me too. There you go.
You know what? I'm going to have to just close out this show. I mean, I can't allow any more discussion to go on here because we have all three panelists on agreement on a topic that potentially is very fraught. So we're going to close on this note of harmony. We're all going to sing Kumbaya together. Nicole Gorovsky of Jenkins & Kling, thank you so much for joining us today.
Thanks for having me.
And Arindam Kaur of Nelly, thank you for joining us.
Thank you.
And Bevis Schock of Schock Law in Clayton. Boy, Bevis, you always bring a lot of interesting points that I think are challenging to all of us. So thank you for joining us.
It is an honor to be asked, and I will always serve.
I'm going to hold him to that.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.